Welcome back to the Legal Alternative Podcast with me, Sam Pawson. Joined as ever by Nils. Nils, how are you?
Very good, Sam. You?
Good, very good. What we got coming up today?
So, what's in our inbox, first of all?
Yeah.
I've got a sanctions case, and I believe you're talking about some neurodiversity.
That's right.
I believe. Then we'll have a quick update out of the office and a very good question again from the viewers this week.
Good stuff. I think you're first.
I am. It's another fairly straightforward matter, actually. We spoke recently about sanctions and how it's easy to fall into the trap potentially of a regulator. Well, again, this concerns Russia. Not going political. I was reading about Russia this weekend. Donald Trump's perhaps changing attitude, possibly. But there is an Office of Financial Sanctions implementation. They're not a regulator I've actually ever heard of or been against professionally. So this is something that's come in my inbox via the updates that we received. So a shipping company has been fined £5,000 for breaching a number of different regulations. Actually, I'm reading directly off this because they're quite. So Section 146 of the Police and Crime Act and also Section 74 of the Russia Sanctions EU Exit Regulations 2019. And this company was actually contacted by the OFSI and asked to explain itself as part of a larger, what the update that I've received terms quite a complex investigation. It didn't respond by that deadline, despite reminders being sent. A response was eventually sent, but it was deemed that there was no reasonable excuse for that statutory deadline being missed. So the failure to provide a reasonable excuse was upheld, and the OFSI concluded that an information offence had been committed, and that a penalty of £5,000 was the appropriate outcome. It ultimately also concluded, the OFSI, that although this is not particularly what I want to talk about, that this particular shipping company had breached the financial sanctions other than in respect to the information offence. So if you do have dealings with foreign countries, obviously I wouldn't ever recommend breaching the sanctions regulations, but I suspect there's companies that could quite easily fall into that just by mistake, and it's then about what you do next. This company didn't cooperate and it received a hefty fine for failing to do so. So a lesson to be learned is, as soon as this comes on your radar, do something about it, get legal advice and go from there, because otherwise that is going to be cheaper than fine.
And ultimately, you would a surprising, well, maybe not a surprising action, just to kind of bury your head in the sand, but you're dealing with some really serious matters. So as always, take advice, act as soon as possible.
We seem to say that a lot.
We do. We do. Yeah. I think it's my inbox. I'm going to talk neurodiversity today, which does come across my inbox a lot in terms of disability discrimination. I have to absolutely caveat at the start, I do not profess to be a neurodiversity expert in terms of kind of workplace culture. There are loads and loads of experts out there. What I want to do and talk about is from a kind of legal standpoint and from an employment law standpoint, which is really important. So it's something that does get a lot of press attention, and rightly so. I still don't think it's handled particularly well by organisations. Again, we're going to talk about reasonable adjustments and a kind of misunderstanding of that. So where the headlines don't meet with practice. So in terms of the introduction and some kind of facts that I think a lot of people are aware of, it's estimated now that 1 in 7 people are neurodivergent in some way. I would estimate in the workplace that figure will be higher, just with the age of your employees generally. I would suggest that figure would be higher. Neurodivergence, I think, as people know, is generally conditions where people have differences in how they think and process information. Conditions I think people have heard of, such as autism, ADHD, dyslexia, dyspraxia, to name but a few. These individuals commonly face barriers in the workplace because of those conditions. Some in terms of the ones we see a lot in terms of communication within teams, processing information, focus on tasks. Organisations, fact finding, can have some difficulties there. So what we are needing to do and to establish in the law, as I say, this is not a social or a kind of for equality reasons. This is what are you legally required to do. We've talked about in previous podcasts. This again comes back to the Equality Act. The vast majority, if not all of those conditions where someone is now neurodivergent, will likely to be held as a disability. What you're therefore avoiding as an employer is obviously discriminating against those employees either indirectly or directly. But critically for the podcast today, I wanted to talk about reasonable adjustments. There's lots of information and cases and reports about where organisations have perhaps failed their employees who are neurodivergent. I want to try and give a balanced approach to that in terms of, well, what is your requirement? What would help? What are we seeing in practice? But also, what are the limits to that? And, we'll focus again on that word reasonable, which I think is always important. So I think in terms of practice in a workplace, what would reasonable adjustments look like with neurodivergent conditions? That may be, for example, if you have employees who are autistic, often struggle with sensory overload, workplace overload, where they're kind of overwhelmed. Often that can be an office-based environment where there is a lot of external stimulation, noise, chat, music, anything in the background that would kind of overwhelm someone. So, what adjustments could you provide? Again, that's looking at your workspace. Is there offices? Is there quiet rooms? Can you provide people with noise cancelling headphones, for example, to provide focus? So there's often lots of things that can be done, often, that aren't hugely costly. I think sometimes there is a failing, I think, in organisations of a bit of imagination and thinking, well, we appreciate this is how we have always worked in the past, but something like noise cancelling headphones are not particularly expensive. For most organisations, that would be in a reasonable adjustment in terms of cost. So we're looking at that. Again, conditions such as ADHD, often difficulty for kind of managing time, switching environments. Again, can we look at flexible working? Can we use AI task management tools to kind of help people with these types of conditions? How are you managing that staff in terms of check-ins with them, supervision to make sure that a workload doesn't come on top of someone? Dyspraxia, dyslexia, again, often individuals can struggle with complex forms, applications. I think you get a lot we see in practice with individuals with dyslexia or dyspraxia struggling with applications. So again, what is your process? Can that be adjusted? There was actually a recent case in the employment tribunal where it was held that allowing someone with dyspraxia to complete a verbal application rather than what was held to be quite a technical online application, which that individual found difficult. Actually, can they make a verbal application instead? Not always going to be reasonable, but in this case was held to be. So as always, when we're talking about reasonable adjustments, there's not a case that I think a lot of employers feel that anything that is suggested of them has to be done. Anything suggested either by the individual themselves or by a medical practitioner, that they are in some way forced to do that. The law's clear that isn't the case. The word reasonable is critical. And what we're looking at in terms of reasonable is the size, the scale, the scope of that organisation. So organisations aren't held to the same standards. So if you're a multinational bank, supermarket, you will not be held. They'll be held to different standards to, local organisations with a handful of employees. So I think the keys in practice, Nils, that we always talk about is, case by case, actually look at the substance of what has been asked. And I do really think in my experience, there is a bit of a failure of imagination here often. It's this has been suggested. That's not reasonable. We won't consider anything else. So, often we get from clients, we can't adjust this working method. We've worked like this forever. Obviously, there's lots of issues with consistency in treating people in terms of return to work, working in the office. But as I say, simple things like, okay, you haven't got the facilities to allow a quiet room, but have you got facilities such as headphones, such as, other quiet spaces to allow people who struggle with that kind of external stimuli and offer kind of opportunities to them? So important subject, and something I think with a bit more effort and a bit more imagination we can actually stop some of these claims happening. Don't know any views from you on that?
Well, many years ago, and in different types of case, we got quite heavily involved into learning about one of those particular conditions that you mentioned today. And what's struck me is just how complicated medically these conditions are. And I think it's probably going to be important as well to have some medical input, isn't it?
Absolutely, and because all conditions aren't the same, even within that what is a really wide spectrum of conditions. So you may have two employees with a form of autism who medically need to be treated very differently because of it is such a wide spectrum. So yeah, I think it always has to be that dealing with this not just as, well, here's your medical evidence, here's that's what we go off. It is to put both the employee, you as the company, and the medical evidence together to say, well, actually, what can we achieve here, rather than, this is the only avenue we can go down, or we've ticked the box, so we don't have to do it. I think a lot of this can be solved with a bit of foresight and imagination.
Good stuff. So on to Out of the Office. We've got some big events coming up.
We do. So at time of recording, I think next Thursday we will be having our kind of summer social commercial event. We're at Sedulu in Leeds on Park Square. So any listeners wanting to come along, absolutely delighted. This is our kind of commercial networking. So all of our Chadwick Lawrence commercial teams will be there sharing some insight, but mainly to kind of give that networking opportunity, a few nibbles on what hopefully will be a nice summer evening in Park Square would be lovely. So yeah, absolutely. Anyone interested in coming on, drop us a line on LinkedIn or contact us on our emails. I'm delighted for you to attend. What have you been up to, Nils?
I went to Alton Towers.
Lovely.
Weekend. Didn't go to the theme park.
Yeah.
I went to the water park there with the kids. I think that might be why my neck's
Yeah.
actually. Little boy was Lucas really loved going up the water slide, so I did that time after time. So
Yeah.
fantastic.
Yeah.
Really enjoyed it. And then the weather turned, didn't it? Just in time for bank holiday.
Just in terms of bank holiday and half term, we are both being wonderful parents and working through our terms, so not too much to update on. I would mention, final thing, out of the office, I went to a fantastic event at Wakefield Theatre, one of our partners, for their annual gala, which was a fantastic event. I know they raised a lot of money for their charity and their foundation. So great event, really enjoyed it, and lovely to support the theatre. Questions, Neil? I think you've got a good question for me.
Yeah, so I've had a client, it crosses both angles, I think, in terms of law. I've had a client contact me saying if they are employing somebody who they know only has a short period of time with them because of their right to work expiring, do you have to issue that person with a contract?
So I think there's a practical and a legal answer here. I think the legal answer we both agree is, sadly, yes, you do. There is obviously now quite well established, probably 5 years, a right to a contract day one. For all employees. Sometimes actually with people who are even with you for a short time, I think there's sometimes even more of a reason to have a contract for that fixed term duration. And as you say, Nils, for you to kind of connect into your with right to work, it's important to establish that if that is a condition, obviously, of their employment, that is contracted. So as frustrating as it is, my view is obviously legally, absolutely, we do. And I think that would mesh with what you're saying from a regulatory standpoint.
Yeah, absolutely. We want that right to work check done and something in the contract that says you've been employed by Chadwick Lawrence, for example, is dependent on your ability to work in the UK legally.
Yeah. I think the only practical word of advice is if you haven't provided a contract and you're listening, it's all is not lost in some ways. At any time, even if you haven't complied with that day one right, get a contract in place. Obviously, from an employment standpoint, if we're looking at claims risks, the failure to provide that written particulars cannot be brought as a standalone claim. So you are not going to face hundreds of claims for a failure to provide a contract, but best practice, absolutely you do so, because you'd often find when there are issues that can be easily tagged on, and it's then sadly an area that you will lose. It's quite black and white. It's day one or not. So something we're doing, as we said, absolutely, because it's a fixed term nature, get that contract in place. So I think that's it. Brings us to an end for today. It's been lovely to catch up as always. Any listeners, drop us a line with the questions. It's great to answer your questions. So you can contact us, obviously, on our socials, link in description. But that's goodbye from me.
And from me.